meeting of the Special Joint Committee on the Declaration of Emergency, created pursuant to the order of the House March 2nd, 2022, and the Senate March 3rd, 2022. Today's meeting is taking place in a hybrid format pursuant to the House and the Senate orders, and should any technical issues arise, please advise me, as we may need to suspend for a few minutes to ensure all members are able to fully participate. Witnesses should be aware that the translation is available through the globe icon at the bottom of the screen. And I wish to inform the members that Professor Roach has undergone all technical tests successfully, and both witnesses have been informed of their duty as it pertains to responding to questions. I always like to provide a bit of a preamble to the witnesses that, given the nature of the committee, you may find from time to time a parliamentarian may interject to take back their time. They may interrupt you. Please don't take that personal. It's not a personal affront. They just have a long list of questions in a very short period of time in which to conduct them. So we ask that you just acknowledge that if a senator or an MP interjects, that it's not a personal affront to you. So our first panel this evening, we have with us by video conference Kent Roach, professor of the Faculty of Law at the University of Toronto. And here in the room, we have Leah West, assistant professor at the Norman Paterson School of International Affairs for Carleton University. You will each have 5 minutes for your opening remarks, and we'll begin online. Professor Roach, the floor is yours.
Thank you very much for this invitation to assist with the important work of this joint committee. Although I'm a member of the Public Order Emergency Commission's Research Council, I should stress that I speak only in my individual capacity, and indeed I'm not privy to the Commission's internal deliberations as it prepares its report. I've written about the events leading to the declaration of the emergency, both in my book, Canadian Policing, Why and How It Must Change, and in an article in a special issue, volume 70, sub 2 of the Criminal Law Quarterly, where Professor West also has an article. In both of these venues, I suggest that the use of emergency powers was related to policing and policing governance failures. This is an important matter, even when the Emergencies Act is invoked, because Section 20 of the Emergency Act preserves the existing, and I would submit fragmented and frankly dysfunctional governance silos of the local, provincial, and national police. Let me make 3 points. One is if you compare the police responses in Ottawa and Toronto, you will see that the Toronto response was more effective and reflected the lessons of the Morden report, that there is and should not be watertight compartments between policy and operations, something that was inelegantly referred to more than once in the Emergency Commission as church and state. This lesson should have been learned long ago, at least since the 1981 Macdonald Commission, which, like the Supreme Court in its 1999 decision in Campbell and Charose, stressed that police independence is limited to the ability of every police officer to make law enforcement decisions about who they will arrest and investigate. Everything else, in my view, is potentially a matter that the responsible governing authorities, the democratically accountable authorities, can assume responsibility for. In a democracy, the police should not be self-governing. My second point is to address you to Bill C-303 before Parliament. It is a good idea in that it recognizes that the responsible minister can direct RCMP policies in the form of public directions. It has the potential to clarify police governance. Unfortunately, however, it continues to define police independence too broadly by exempting RCMP operational decisions, including day-to-day operations, from the ministerial directives. The phrase operational only occurs in policing laws in Ontario and Manitoba and has indeed caused much confusion. And the sort of undergovernance that led to the Ottawa Police Board having no published policies before the convoy arrived about how to police protests on Wellington Street. They had policies on labor protests, on Indigenous protests, but no public policy on Wellington Street. And my final point is we need such policies. We need to think creatively about these policies, including how to use barriers as a means to reconcile the right to peaceful protest with human safety. I would urge this committee to be creative and explore the suggestions of former Senator Vern White about a redesign of Wellington Street. I would also urge you to consider giving the RCMP a clear lead in policing the parliamentary precinct and border crossings, but only if its governance and resource policies are addressed. Bill C-303 could be part of this reform, but only if its overbroad definition of police operational independence is rejected through an amendment. One limiting police independence. Police independence should also be defined so that it does not impede the ability of police leaders to control and manage their organizations. And again, this can be done if we limit it to law enforcement discretion. I'd be happy to answer any of your questions. I have particular concerns addressed in my Criminal Law Quarterly article about some of the elements of the offense with respect to that was enacted under the Emergency Act. Thank you very much.
Thank you very much for your intervention. We will now go with 5 minutes to Professor West. Professor West, the floor is yours.
Thank you, Chair, very much for the invitation. In the short time I have with you today, I'd like to focus on two issues of statutory interpretation that I think are exceptionally important to this committee's work. The first is the reference to the CSIS Act in the definition of public order emergency, and the second, which may not get to, I admit, is any other law of Canada criteria in the definition of national emergency. Before getting into the specifics, I think it's important to set the stage with the modern principle of statutory interpretation and a few core rules. So the leading and well-established Supreme Court precedent on statutory interpretation comes from Rizzo.
Monsieur le Président.
Yes.
Peut-être juste.
Chair, could you please ask the witness to slow down somewhat, because I get the impression the interpretation is having a hard time keeping up.
Did anybody else have issues with the interpretation? No?
Okay.
Feel free to back it up a little bit if you want to.
No, it's all right.
You're only a minute in.
Chair, point of order. Could the witness back it up a little bit so we have the proper context, please?
Would you mind starting from
Sure.
the beginning? Thank you.
From the beginning, I'll save the welcome thank yous again. So the first point I'd like to address is the reference to the CSIS Act definition in a public order emergency. And the second, which I hope to get to, but if not in questions, is the definition of any other law of Canada and those criteria in the definition of national emergency. So setting the stage, the principle of statutory interpretation, or the modern principle we apply, is set by the Supreme Court in 1998 in a case called Rizzo and Rizzo Shoes, and it's really become a mantra. So the court wrote, "Today there is only one principle or approach, namely the words of an act are to be read in their entire context and in their grammatical and ordinary sense, harmoniously with the scheme of the act, the subject of the act, and the intention of Parliament." There are a few assumptions that underlie statutory interpretation using this principle. One of the clearest is the presumption against tautology, meaning every word in the act must be given meaning. Every feature is deliberately chosen to play a role, and there are no unnecessary or meaningless language in statutes, and the legislature does not make the same point twice. A second presumption is that of consistent expression. It's presumed that the legislature uses words and patterns of expression in a consistent way. Once the legislature adopts a particular way of expressing something, it avoids variations and prefers to express the same meaning in the same way. And of course, undergirding all of this is the concept of the rule of law. which means in part that law as written has to mean something tangible, articulable, and discernible to those who read it and are subject to it, those tasked with interpreting it, so that those that exercise power given to them through the law cannot do so by whim, abuse, or prejudice. Now, this brings me to the definition of a public order emergency. The plain text of Section 16 states that a public order emergency means an emergency that arises from threats to the security of Canada that can be so serious as to be a national emergency. Threats to the security of Canada is then defined in the Act for the sake of that portion of the Emergencies Act. And Section 16 states that the phrase has the meaning assigned by Section 2 of the CSIS Act. Just looking at this provision, the statute tells us not only does the EA incorporate the words in Section 2 of the CSIS Act, but also incorporates the meaning assigned to it under that Act. And as we know, and as I just said, every word used in a provision has meaning and its use is deliberate. This understanding is consistent with the clear intention of Parliament. During the debates over the Act, much of the concern around the Emergencies Act was the ability to invoke the Act to quell public dissent under a public order emergency. And moreover, we know that during the FLQ crisis, the War Measures Act had been deployed against politically motivated terrorism. So not surprisingly, this section of the Act got a lot of attention. And in response to those concerns, it was made clear that only protest and violence that would meet the definition of a threat to the security of Canada, as defined in the CSIS Act, and then only those threats that also met the definition of a national emergency could be the basis for a declaration. And this is what the bill's sponsor, Perrin Beatty, referred to as a double test. He also reminded members of the House who were concerned with how broad and vague the CSIS Act definition is, that that definition had received exhaustive scrutiny by Parliament. Thus, we know from both the plain reading of the text and the clear intention of Parliament that the meaning of threat to the security of Canada comes from how it's understood and applied in the CSIS Act, and the breadth of the CSIS Act definition, which is, I'd argue, quite broad, is then narrowed through the definition of a national emergency. And I'd also put forth that there's nothing in the elements in the other provisions of the Emergency Act that are inconsistent with this understanding or call into question this interpretation. Additionally, the incorporation of Section 2 of the CSIS Act is actually not unique to the Emergencies Act. The same move is made in the Security Offences Act, the Access to Information Act, and the Privacy Act. And in each of those acts, who is doing the interpreting in terms of what meets the threshold is not necessarily CSIS. In the case of the Security Offences Act, for example, it's the Attorney General when deciding when to seize jurisdiction from the provinces. Finally, I want to reiterate that the requirement is that the national emergency arises from a Section 2 threat. This is a causal requirement, meaning what is a national emergency of an urgent, temporary, critical nature and beyond the provinces arises from threats of serious politically motivated violence, meaning economic, reputational harm, all the other things that we certainly saw as a result of the crisis in Ottawa and across this country, has to be the result of serious threats of violence as understood in the CSIS Act. So I know I'm now over time. Hopefully I can talk about what any other law of Canada means in questions. Thank you.
We will now begin with our 5-minute segments, interventions, beginning with Mr. Motz. Mr. Motz, you have 5 minutes and the floor is yours.
Thank you very much, Chair, and thank you to Dr. West and Dr. Host for being here. Being you didn't get complete your opening remarks, could you table those with the committee at the end of today so we could have access to those, please? Thank you so much. So, Dr. West, you had indicated publicly that a national emergency is a public order emergency, and it can't just arise from incompetence in various municipalities or provinces. It has to arise from a threat to the security of Canada, which typically means terrorism or violent extremism, and to meet the threshold to invoke the Act. Now, have you seen anything, any documents, anything that you've looked at since the invocation that this threshold was met?
Well, I don't think it's fair to ask me that because I haven't seen all of the intelligence that was relied upon by CSIS or the Cabinet especially cabinet, to make that decision. My point was then, and I would make the same point now, that the key is that the threat to the security of Canada has to be what drives the emergency, rather than it being the byproduct of the emergency. And that was really the key of what I was trying to say, is that it can't be, there should be a causal connection there. That's how I interpret the statute, rather than it being something that happens as a result of another reason for the emergency.
Fair enough. So, one of the things that that I find very concerning, I think, and many Canadians do, is the precedent that will be set once Justice Rouleau releases his final report. He will essentially either agree with or disagree with the government's expansion of the CSIS definition and the thresholds, which served as a foundation for the rationale for invoking the Emergencies Act. Dr. West, can you speak to why it's so important that future governments be constrained by law and like the CSIS Act when it comes to using the Emergencies Act?
Yes. Well, I think the rule of law, again, requires that, especially where the legislature speaks and does constrain the power of the executive, that especially in times of crisis, that the executive adhere to those constraints imposed by the legislature. I think that the Emergencies Act has incredible amounts of discretion for the executive, amounts of discretion there, but when Parliament has chosen to be very narrow, in this case, in its use and definition of threats to the security of Canada, it's important that that be respected, because it was a deliberate choice, and the rule of law is the backbone of what makes us, a liberal democracy that thrives on the rule of law.
Okay, fair enough. Thank you for that. One of the things that I found interesting was at one point you actually tweeted that there were, in your opinion, there were holes in the Prime Minister's legal analysis. Can you expand on what you meant by that and what that means in your opinion?
So, my understanding of what the Prime Minister said when he testified before the PIOC was that he took into account different considerations than CSIS when making the determination as to whether or not the definition of 2C was met, and he also viewed 2C to be more broad, and that I don't think he said that. I think he said something to the effect, I think the CCLA had him acknowledge that the thresholds were the same. But then subsequently, when asked what the factors were that led him to believe that Section 2C was met, he listed a variety of threats and of violence, of weapons, etc., that he relied on to make that decision. But I suspect that CSIS would have also relied on all of those factors when making its assessment. It didn't seem to be anything that would not have been subject to CSIS's consideration.
Okay, so if I'm understanding you correctly, the broader interpretation that we are left with that we haven't seen could include the same sort of things that CSIS was reasonably looking at. Is that what your assessment would be?
Yeah, it was. If it really was it was the fact that he suggested that he viewed the standards to be the same between the CSIS Act and the Emergencies Act, but that he relied on different factors. But then the factors listed would have been factors that would have been considered by CSIS.
And when CSIS said there was no threshold under under Section 2 to meet the threshold to invoke the Emergencies Act.
Yes, that's my understanding.
Thank you. Thank you very much.
Excellent. We'll now move on to Mr. Varani. Mr. Varani, you have 5 minutes, sir, and the floor is yours.
Thank you very much. Thank you to both witnesses for their testimony. I'm going to direct my questions to Professor Roach. First of all, it's nice to see you, Professor Roach. You've actually, in a fit of coincidence, you've got 2 U of T law alumni here at the committee, at least 2. But I'm going to ask you about 3 areas of questioning. So you mentioned some of the things you've written about. A couple of things that I've read of yours. I'm going to cite to you some of the passages in an article called "The Dilemma of Mild Emergencies That Are Accepted as Consistent with Human Rights," which appeared in a German publication. But it touched upon something that you had identified a little bit in your opening, but I want to take you to it. It's about this idea about possible areas for improvement and this idea that policing is multi-jurisdictional, particularly in a federation like Canada. And what you said in that article is that one limit of the inquiries triggered by the Emergencies Act is that they are limited to examining the federal government's actions, whereas the roots of the Ottawa occupation and the Windsor blockade are in failures of local policing, including planning for protests. There's no requirement that Ontario, which has ultimate jurisdiction over local Ottawa and Windsor police, will call a similar inquiry. This is an omission given that emergencies are defined as something that exceeds the capacity of the province. We actually saw, and I know you're intimately familiar with the inquiry that Justice Rouleau was leading, we actually saw an effort to actually have the Premier of Ontario come before that inquiry, which was then subject to some litigation, which was successful from the perspective of the Premier not being interested in participating. Can you tell us, from your perspective, what would you recommend that we should be doing as a committee to try and rectify this situation, given the constitutional parameters that we're operating under with the division of powers? But how would you see going forward future inquiries involving, by necessity, all three levels of government when there is an emergency such as this that gets triggered? So over to you, Professor
Yeah.
Roach.
Thank you very much. I mean, you're quite right that the Premier and the Solicitor General did not testify and successfully invoked parliamentary privilege. So that's obviously a problem going forward. But I was actually surprised at the level of provincial and municipal buy-in at the Rouleau Commission. So, I mean, it seems to me that really the only way that the federal government can control that is by giving the federal government and federal policing a lead role in those areas, whether it be the parliamentary precinct or border areas. I think that's really the only way that the federal parliament can respond to this interjurisdictional nature. And Professor West has mentioned the Security Offences Act, which is not well known enough, but we actually do have precedent for federal preemption of provincial areas in the national security area. And so this might be an area for you to consider if you want to ensure that there will be full accountability for future emergencies should they develop around these same areas of federal interest.
So let me explore that with you. I've just got about a minute and a half left, I believe, but because your article also talks about intelligence failures and policing failures and sort of links the two in that same article. And it talks about sort of underestimating right-wing extremism to the detriment of sort of overestimating things like Al-Qaeda and Daesh, for example,
Right.
and then the policing failures that might follow therefrom, because ultimately this was a policing issue. So what would you recommend in terms of what we should be doing with respect to policing failures? Because I note that your article also talks about how Indigenous or racialized protesters are sometimes treated versus how these blockaders were treated for 3 weeks in Ottawa, and perhaps some of the biases that were involved. So if you could just elaborate on that point.
Yeah, I mean, the OPP operational Hendon has actually gotten a lot of praise, and I'm not going to join that bandwagon because my concern is that intelligence operation started with respect to Indigenous occupations, and also some of the product that we've seen uses phrase like the Patriot movement, which don't really seem to me to kind of strike down. And so although the RCMP and CSIS are subject to fairly rigorous scrutiny by NSIRA, the OPP and municipal forces, when they collect intelligence, are subject to very limited scrutiny only by the Ontario Independent Police Review Director if that person has enough resources to do systemic reviews, which my understanding is they don't. So, you know, again, this may be another reason for the federal arms to play a lead role, because we cannot guarantee adequate levels of accountability at the provincial level.
That concludes the round. Monsieur Fortin.
Mr. Fortin, you have 5 minutes. You have the floor. You have the floor. Thank you. Good try. So, given that the floor is mine, Ms. West, good evening and thank you for appearing this evening. Earlier, I was listening to your responses to Mr. Motz in terms of being able to justify emergency measures. And you said that you weren't able to determine whether or not the use of that act was justified.
OK. Alors,
So what I would like to know is this, Ms. West. If I tell you that, let's say theoretically, a proclamation was based on legal advice, do you think you would need to read that legal advice in order to determine whether it was justified, or do you think that the events in themselves would be enough to determine whether or not there was a threat to the security of Canada?
I think it would help if to read the legal advice would to help me understand if my interpretation of the act has any holes in it. I think I came to watch what happened, the invocation, and judge everything from it based on my reading of the act as someone who's written about it before it was invoked, who's someone who's advised on it during COVID. I have a clear understanding in my mind what it means. I'm not saying that there could not be some sort of legal precedent out there that could potentially change my mind. I would have to read that to see whether or not I would concede anything. And that would be the value in reading the legal opinion, is to see whether or not the common understanding of the act and especially Section 16 could give way to a different interpretation as suggested by the government.
et en fonction.
And in terms of what you already know about the situation, do you consider that there was a threat to the security of Canada or not?
Je vous dis,
Now, Ms. West, if I were to tell you that we're being served the following argument, and that is that there has to be a broader definition rather than what is literally written, I'd like to know what your opinion is. In other words, what do you think that the broadest way possible to interpret that definition would be, keeping in mind that there is going to be a proclamation, an invocation of an emergency situation? So if you were going to interpret it very broadly, how far would you go in order to conclude that that action was justified?
Interesting question. I think the definition as it stands is already quite broad. And I think that reflects the concerns of opposition MPs and the Canadian Civil Liberties Association and the Canadian Bar Association when the Act was first introduced. The definitions of threat to the security of Canada is intentionally broad and somewhat vague because CSIS is an agency that needs to be able to interpret potential threats, things that are not quite there yet and things that are hard to discern. So having very firm lines around what is and what is not up for potential investigation, like in the context of a criminal investigation, is something that is avoided by having more broad and vague language used in the CSIS Act. It's not so vague as it does as to denote anything, but it is quite vague. And so to say how broadly could we interpret it, I have a hard time with any broadening of it, right? Especially when we talk about 2C, because of what we're talking about here is terrorism and violent extremism, that these things are already quite hard to put your hands around to understand what is or is not violent extremism, for example. So to say that as we currently understand it, we could interpret it even more broadly, I don't see where there is a limit. I think we have to rely on the text, and where there is discretion is that weighing of the factors to decide whether or not that definition is met, not what the words themselves mean.
I did allow the
Sorry.
intervention to go longer because I think it was important, but that was
Merci.
5 minutes. And if I could ask Professor Roach, can you please lift your mic up a little bit just for the purpose, of the sound? And Senator, would you be able to take the chair while I do my intervention for 5 minutes?
I would absolutely.
Thank you. And with that being said, through you to Professor West, you had acknowledged that your legal opinion is only formed based on the information that's been made publicly available, and suggested that further scrutiny of knowing what the government knew and how they reacted to it would help in your legal analysis on whether or not the government made the right choice. Is that correct? Professor Roach, do you share that same opinion?
Yes. I mean, for example, it's been mentioned that the OPP had undercover operatives in the Ottawa protest. We don't know what they came up with. So, I really think that you can only fully investigate this if you do so in a manner that is in camera, subject to national security confidentiality. And I would add that I think, moving forward, you should consider that an inquiry would have powers to go behind solicitor-client privilege. And CIRA, for example, has those powers.
I would put to you that Parliament has those powers, that the conventions of cabinet confidence are only a convention, and that ultimately we're the Grand Inquisitors of the nation. But the point that I wanted to make was more on the legal opinion, because this has been a challenge even for this committee, even given our parliamentary privileges, is getting access to the legal understandings in order for our own process to take due course and to be able to provide analysis. So I'll put the question to you and ask you if you could answer it briefly. Professor West, would you benefit from having the legal opinions, the internal legal opinions of the government made public for scrutiny and for the ability for subject matter experts like yourself and the public to have the ability to ultimately scrutinize and yes, and Professor Roach, would you agree that a legal opinion would be valuable in terms of looking forward on this topic, regardless of what side the issues are on?
Absolutely.
And you had mentioned the notion of any other law in Canada, and I do want to give you the opportunity to speak to that, Professor West, because I'm curious you brought it up, but I'm not clear about where you were going with it.
Any other law of Canada means any other federal law, not literally any other law of Canada. This was decided by the Supreme Court in Roberts in 1989. And in that case, it was interpreting Section 101 of the Constitution, but it held that either it includes federal statute or federal common law. Typically, federal legislation says any law of Canada or of a province or any other law if it's used to denote wider application. And the reading of any other law of Canada makes more sense in this if you look at parts A and B of the definition as well. Part A would become redundant because it already says it has to be beyond the authority and capacity of a province, and Part B doesn't have anything to do with provincial jurisdiction. So realistically, once the executive has decided that the criteria in the chapeau and A or B are met, all they need to look to then is whether or not there's other federal statutes for them before they invoke the Emergencies Act.
I have to say I regret not inviting you to this committee earlier, because that is a significant interpretation that I don't think we had been made aware of. So just so that we're clear and for the purpose of the record, you're suggesting in that analysis, in that legal opinion, that regardless of the fact there was a breakdown municipally with the local police here, regardless of the fact that provincially they had tools both through the Ministry of Transport, maybe perhaps some other incentives for the truckers to leave in the occupation, that really doesn't matter. Even if those remedies were available but not used, as you understand the Act, it is only federal, the federal laws or regulations that have been exhausted.
That first part goes to, if you're invoking under Part A, that goes to authority and capacity of the province, right? So you should be looking to see whether or not there are other authorities for the province to remedy the situation. Once you've decided that the province or the municipality doesn't have those authorities, and you've decided that the definition is met, the federal government only needs to look at
Right.
its federal.
And I want to
tool
get
belt.
very clear about that first point.
Yep.
And so even if they have the authority, is it your opinion that if they have the authority but don't use it, it's the same thing? Like, because this is for me the practical crunch of the matter.
That is-
Having the law and then having an effective failure of policing, I don't think was contemplated by Perrin and Beatty when this was correct. Would you agree with that assessment?
I would agree that the Emergencies Act contemplates everyone doing their jobs.
Right.
So it does, however, say authority or capacity. So if for some reason they don't have the capacity to fulfill their duties or use their authorities, that's a separate question, because it does say authority or capacity.
Sure.
It does not need to be both.
Got it. Thank you very much for that. That's great for my own analysis on this. Senator Boniface, you have 5 minutes. What happened? Oh, you were telling me too. We have great co-chairs of this committee, by the way. Thank you so very much, and thank you for the little bit of extra time. I note that. Senator Boniface, you have 5 minutes. I have taken back the chair, and the floor is yours.
Thank you. Thank you both for being here. I think I agree with the chair. It's important to have your presence and your view, so thank you for taking the time. I'm going to address my first comments to Mr. Roach, Professor Roach. First of all, thank you for your comments. I'm particularly interested around some of your references to police and police jurisdiction and the role of the province. And so I'd be interested in you giving a better sense, if it had been a perfect world, what you would have expected in terms of the role of the province.
Well, I would look to the Toronto example where there were barriers put in place that protected the critical infrastructure of the hospital. There was a full briefing by a police board of which the mayor actually sat on, and there wasn't the sort of disarray that you saw both in the Ottawa Police and in the Ottawa Police Service Board.
To the directing operations, which you're very familiar with, and I think you covered in your book as well. And we heard that here as well in terms of this, what I think is a misunderstanding by people in political areas of the role of the operations of police and where they can intervene and when they can't. Can you just elaborate a little on that? Because that's a fundamental question here in terms of responsibility.
Absolutely. I mean, if the police have complete operational independence, then they're essentially self-governing, and they're only restrained by the fact that we have good police that are generally restrained. And so back to the Macdonald Commission, they always said policy of operation was a matter for the responsible minister. But it's too easy for the responsible minister or the police service board to say, no, that's a matter of operation. And that's why I was quite distressed to see in Bill C-303, which I think is a worthy effort, again, this mantra of operational independence, which is extremely confusing. Justice Morden had to devote 100 pages of legal analysis to try to elucidate it. And his messages obviously didn't make it to the Ottawa Police Service Board.
So agree with me that certainly in the Ipperwash inquiry, which you and I are both familiar, this was one of the fundamental questions on the ability of politicians to direct the police. And there was certainly, I think, some information out of that may have been helpful, that would be helpful to this issue.
Exactly. And the part of 303 that I think is good is it picks up Justice Linden's recommendation that, this is going to be an area that will change over time. And when the responsible political authority assumes responsibility, then they should do so in writing, and that there should be a presumption that what that direction is going to be made public. So I think 303 is going down the right route because, there's one of the things Justice Linden said is there's no one-time solution between policy and operation or church and state. It really is a dynamic, contextual sort of issue. And in a democracy, we have to make sure that the ultimate policies are set or not set, as the case may be, by those who we can have some democratic accountability over.
So I want to pick up on your questions or your comments around intelligence, and particularly intelligence collected by the police in this case. What would you suggest in terms of oversight or review that might be beneficial in terms of those sorts of issues? Because it's shared amongst 3 levels.
Exactly, yes. Well, I mean, I think that if there were some formal coordination that had a federal involvement, then you would ensure that NSIRA and the National Security Committee of Parliamentarians could at least have some review over that. The problem is that there's nothing like NSIRA or the National Security of Parliamentarians at the provincial or municipal level, and therefore you have an accountability gap.
Thank you. I'm going to try this again for Senator Carignan.
Senator Carignan, you now have the floor for 5 minutes. My question is for Professor Roach. We heard that the measures that were taken under the Emergency Measures Act were subject to the Charter. So we were told, don't worry, the Charter applies. And so what do you think then about the order to freeze the financial accounts of any people who were participating in the convoy? Do you think that would be a breach of Section 8? I'd like to recall the LaRoche Supreme Court ruling where it was said that blocking those funds was actually a seizure.
Merci pour votre.
Thank you for the question.
Anyone can say things are charter proof, and I've written extensively that the charter only sets minimal standards. But there were many aspects, not only the financial aspects of the emergency order, that I think could be charter suspect. And being able to seize or freeze assets without any discernible due process is something that could be vulnerable. Also, the use of the breach of the peace concept in, I believe it was Section 2 of the regulation. We actually don't have an offense of breach of the peace, and it is vague. And so I would not be willing to write a clean charter bill of health for either the financial or the protest related measures. Similarly, the definition of interfering with trade as an offense. That is a staggeringly broad offense. And so, I think it's important that we apply the charter standards, but the fact is that's never going to happen before a court. And just because the government says something is consistent with the charter doesn't mean that it is.
We also heard another argument that really made my hair stand up on end. Me too, says the witness. So we were, obviously, there has to be action on the part of the state. But what we were told was, well, we weren't the ones who seized or froze those accounts. It was the banks. So it's not the same as search and seizure. It's the banks that seized or froze the assets. So what do you think of that argument? Does it have the same effect on you as it had on me?
Yes, I mean, it is technically true that the charter only binds the state, but there are Section 8 decisions under the charter where the fact that the nurse got the blood sample as opposed to the police officer does not immunize something from the charter. And of course, in the area of financial sanctioning, the use of financial institutions at the direction of the state, I think could very well be subject to charter scrutiny. And I think the courts will be sensitive to the fact that if they hold the opposite, then it really does create a pretty large accountability gap, because so much in the area of financial sanctions or indeed surveillance is now done by the state directing the private sector. So I think our courts are aware of this and interpret the charter in a broad way, in part because they don't want to provide governments with incentives to basically say, here's someone not subject to the charter, why don't you go and do our dirty work for us?
That does conclude the 5 minutes. So, je m'excuse.
With my apologies.
To Senator Harder. Senator Harder, you have 5 minutes, sir, and the floor is yours.
Thank you very much, Chair. My question is, first question is for Professor Roach. Professor, you've argued that Canada has not taken the threat of far-right extremism seriously enough. In the wake of the convoy protests, can you elaborate on where we've fallen down and what threats we must consider going forward, and whether or not we have the legal tools to deal with the threats as you see them?
Yeah. Thank you, Senator Harder, for that question. I think that, CSIS came very late to recognizing that violent extremism, particularly from the far right, was taking far more lives than terrorism inspired by Al-Qaeda or Daesh. And so, again, I think when we evaluate CSIS's determination that there was not a threat to the security of Canada, we have to recognize that it was coming fairly late to that game. I'm not saying whether that means that they were right or wrong, but I think that that is relevant. I think since that time there has been, but again, I think in Operation Hendon, you see in references to the Patriot movement an assumption that the far right in Canada will be very similar to the far right in the United States. There are certainly transnational dimensions to this that we've unfortunately seen in New Zealand and Buffalo and elsewhere. But I think we need to develop a much more sophisticated understanding of ideologically motivated extremism. And I would expect that to come mainly from CSIS as opposed to the police, because the lessons of the Macdonald Commission that police are not trained to have the sort of political skills to do intelligence, and particularly saying when extremism, which is I think something we shouldn't necessarily be concerned with, passes into violent extremism. That's not necessarily a call that I would expect the police to be best suited to make. And I would rather have CSIS making that subject to ministerial direction and subject to all the oversight that comes with it. Do we need more legal tools? I think that really remains to be seen. I don't think that, and I agree with Professor West, that there's lots of people in the security establishment in the federal government that want to expand amend Section 2 of the CSIS Act. Well, you're supposed to do that before, not through interpretation. I agree with Professor West that that's a kind of basic in a rule of law state. But I also think that that is not something that should be undertaken on the fly. I think it is extremely serious, especially given the new powers we've given to CSIS to engage in threat reduction. And maybe we need to go back and really rethink the entire CSIS police distribution. We also know through the RCMP's institutional report to the Commission that I think it has 4 different intelligence sections, including on ideologically motivated extremism. I mean, the Civilian Review Board is not going to be able to keep up with that, especially when it has to deal with CBSA. So I hope NSIRA and the National Security of Parliamentarians is taking a hard look at that, both from a rights perspective, that we're not branding extremism as something that should be subject to intelligence, but also from an efficacy point of view that we're actually doing it with the needed resources and skills that are required. Sorry for the long answer.
It was a long answer, but it was very worthwhile. Chair, do I have time for another question? Very, very quickly then, Professor West. Director Viano testified before the committee, as you well know, with respect to his view of the legal framework for the action that was undertaken. Are you disputing his testimony?
No. Director Vigneault said that he was not of the view that what he witnessed was a 2C threat, but then was provided legal opinion that told him he could take a broader view of Section 2C, and then based on that, provided his advice as a advisor of national security. I think that's permitted.
Thank you.
We just acknowledge that Patterson's not here. We will go on to the next round. It's a 4-minute round, and we will give the floor to Mr. Brock. Mr. Brock, sir, you have 4 minutes.
Thank you, Chair. I'd like to thank both professors for your attendance today. To you, Dr. West, the Prime Minister promised Canadians when he formed government that he would run an open and transparent government. He agreed to cooperate fully with Justice Rouleau when asked to testify. Yet he and his cabinet have hidden behind the principle of solicitor-client privilege in not releasing the legal advice he received. A just trust us argument is unacceptable to Canadians. Without the benefit of that opinion, you opined in a legal article, and this was co-authored by yourself, Michael Nesbitt, and Jake Norris in the the Criminal Law Quarterly, that for the government to have properly justified the declaration of a public order emergency, the government needed to base its invocation on 3 novel, unconventional, and previously unanticipated ways of interpreting this legal threshold. Can you opine on that? And the secondary question to that is, this article was written before all of the evidence was heard. Does your opinion still stand? If not, how does it differ?
So it changed slightly because we wrote that on the basis that Section 2C was being interpreted as we would interpret it in the CSIS Act. So that's what we were assuming, that when Cabinet read 2C, they read it the same way that we would have. And so not having any evidence at the time the article was written that there was such serious violence or threats of violence that would amount to 2C, we said, well, there must be some novel way of interpreting what serious violence means. And based on the Section 58 justification, we looked at what was there, and it was serious economic harm in particular. Now we've heard that it wasn't the serious economic harm. It wasn't, intelligence or evidence that wasn't available to the public. It was a different definition of 2C that was relied upon, and that was something that we had not anticipated when we wrote that article.
Okay. You appeared on CBC Power and Politics on a number of occasions during the Rouleau Commission, and the question that was put to you and another professor was what we learned from the Prime Minister's testimony. I also looked at your Twitter feed, and in a tweet in and around that same time frame, this is probably during the day or perhaps the day after the Prime Minister testified, in a tweet you said that Trudeau, Prime Minister, is making a compelling argument if you're not a lawyer. Please expand on that.
It's a lot to unpack. Basically, yes, thank you, is that what I heard and what I've heard all the way through as someone who's trying to take the facts and the understanding and apply it to the law is a lot of facts being applied to different elements of the definitions, but they're not ever necessarily in the right order. They're not, you don't meet the first hurdle before you get to the next one, before you get to the next one. They're all kind of, they're just applied as if there's not a structure to the act. So you get facts that talk about one element of the definition and then facts that talk about another, but they don't really lay it out in terms of you have to meet this threshold and this one and this one. And so I think if someone's just reading the act and isn't, someone who's a statutory interpretation nerd, you look at it and you're like, oh, well, all of the things here match up with all of the things that are in the act, so that makes sense. But that's not the way the statute's laid out. There's a series of thresholds that need to be met, and they're, each word matters. And that's why I found, compelling, but not if you're looking at it with, through the eye of someone who's keen on statutory interpretation.
For those who may be keeping track, I am allowing the witnesses to finish their thoughts and their answers, but your intervention has been completed. We will now pass the floor over to Ms. Bendayan, who has 4 minutes. The floor is yours.
Thank you, Mr. Chair, and I'll continue along this line of questioning Professor West. Earlier in your testimony, you indicated that you obviously don't have all of the facts because you're not privy to a lot of the security and intelligence information, among others. And just now you testified that you're applying the facts to the law, but you would agree that you don't have all the facts? Okay. I also looked at your Twitter, and we seem to have picked up on the same article of November 30th last week, where CBC reported more details about the murder plot in Coutts, Alberta, that pipe bombs and more than 36,000 rounds of ammunition were seized by the RCMP there. Included in the CBC story were mentions of unsealed search warrants that included text messages between those charged and, quote, the bosses, which told the charged men, again, quote, the real goal for the protests included altering Canada's political, judicial, and medical systems, end quote. You tweeted about this story, and in your quote tweet you say, and I'm quoting you, Professor West, curious as to why these men are not charged with terrorism offenses, end quote. I was just wondering if you could provide us your insights into what you were referring to, and in particular the danger of ideologically motivated extremist violence.
Certainly. So the definition of terrorist activity, which is the basis for a number of terrorism offenses in the criminal code, which is different, I would say, than what is in the CSIS Act definition. It's much narrower in the criminal code, and it requires 3 things. It requires an intent, it requires a motive, and it requires a certain level of action. And I think based on the information to obtain that was conveyed in those articles, it seems that there is evidence that supports all 3 of those requirements. And that's why I asked why, terrorism offenses weren't added to the charges subsequently after they were laid.
Mr. West, I'll move now to Professor Roach. There are 2 articles, Professor, among many more I'm sure that you've published on this topic. I would like to refer to your May 12th article where you state, Professor, one issue that should be examined is whether CSIS failed to collect and share intelligence on whether there were links between the protest and far-right violent extremism. Canada's intelligence agency has been slow to accept far-right terrorism as a security threat. And you go on. I wonder if, in connection with this article and that statement, you could provide, perhaps in writing to the committee, because my time is very limited, your recommendations about how we might address that. And if I could also point you to your February 14th, 2022 article, which was, of course, at the height of the occupation, you stated that the RCMP, acting as federal police, only has jurisdiction over actual federal property. It is the local police that is responsible for public streets that run in front of Parliament buildings and the main highway in Windsor leading to the Ambassador Bridge. Such arrangements should now be reconsidered. Again, thinking towards the recommendations that this committee will make, if you could provide your thoughts to the committee on those statements, as well as your statements, if I understand your testimony here correctly, to the effect that all of this is essentially the result of a failure in policing. I'm not sure if you would like to expand on any of those points in the short amount of time I have left, but again, if I could get your commitment to provide your thoughts in writing to the committee so that we may benefit from them.
Well, I mean, as I suggested in my opening statement, thought should be given to giving the RCMP primacy, both with respect to the broader parliamentary precinct and with respect to border crossings. On the issue of kind of far right violent extremism and whether CSIS's response was adequate, I think that is something that NSIRA and or the National Security of Parliamentarians should examine.
Thank you. That does conclude that round. Monsieur Fortin.
Mr. Fortin, you have the floor for 5 minutes. Thank you. Ms. West, I'm going to continue my questioning along the line of interpretation. Now, I don't necessarily want to criticize or support the legal opinion that some may have seen, because we haven't seen it. So as far as I'm concerned, for us, it doesn't exist. But given that you and Mr. Roach are here, I'd just like to talk about the principle of interpretation. From my understanding, when you have a statute or a text, you're going to give it a broader meaning if it's a law. But if a statutory instrument deprives people of rights, there will be a more restrictive interpretation. So if it provides rights, it'll be broader, but if it's deprives rights, if it gives rights, it's broader. If it deprives rights, it'll be interpreted more narrowly.
Président, point of order.
Point of order.
Je voulais pas interrompre mon collègue.
I didn't necessarily want to interrupt my colleague. I wanted to wait for the witness to answer. But in my colleague's question, it seemed that he was implying that there may be members around the table who had seen a legal opinion. Now, if he's referring to my questions to the witnesses,
Specific to a standing order, that is debate.
Il y a personne qui a vu d'opinion.
no one has seen.
You will have another round if you want to refute anything that's been said here in debate. Thank you. My apologies, Monsieur Fortin.
Mr. Fortin. Thank you, Chair.
Merci, Monsieur le Président.
Thank you, Chair. I wasn't implying anything. I was simply saying that that legal opinion doesn't necessarily exist for the purposes of our work because
Back to it. Here we go.
Mais,
Then, where was I? So, there is a more restrictive interpretation of the law when that law is depriving people of their rights. Are you of the opinion that the proclamation of the Emergency Measures Act, are you of the opinion that in this case it was removing rights?
Yes, certainly there were limitations on people's rights through the proclamation of the Emergencies Act. But I think it's important to take a step back and talk about what we are actually interpreting, which is the words of Section 2C, and then how that applies to the declaration of emergency. And so that specific provision isn't giving somebody a right or taking their rights away. So that typical rule in that context isn't one that I think would have a lot of sway either direction, because it's not that element that is either giving a right or taking it away. But the general context, I agree, of the Act, so you might want to consider that when you're thinking about the context of the Act, it is to potentially deny people's liberties.
Merci.
Thank you. My other question is for Professor Roach. I would put the same question to you, Professor Roach. In your opinion, should there be a more restrictive interpretation of a clause when it involves removing or depriving people of their rights? And if so, what interpretation should one be given to the statutes that allowed for the emergency measures proclamation? Did it deprive people of their rights?
Yes, I agree that it did deprive them of their rights. I also think it is jarring that CSIS didn't think the 2C threshold was met, and nevertheless, its director and subsequently the cabinet recommended a proclamation of an emergency. And I really think that, and again, this may lead to the legal opinion, much of it really depends on 17.1.
Excusez, Professor Roach, il me reste...
Professor Roach, I only have a few seconds left, so my apology. But then I just want to know about your opinion about interpreting more broadly when there's an emergency. You're saying that wouldn't be a good thing.
No, I think generally it wouldn't be a good thing, but you also have to remember Section 17.1 of the Emergency Act, which says when the governor and council believes on reasonable grounds. So to me, that may build in a level of a margin of appreciation. But my basic point was, CSIS interprets 2C rather strictly because it does infringe on people's rights. And I think CSIS is well aware of that. And I think that that is quite appropriate.
Okay, that
Merci.
does conclude the round. Thank you very much. I'll pass the chair to Senator Boniface for my 5 minutes. 4 minutes. Oh, see, I was being generous.
Go ahead.
Thank you very much. I think it's important for me at least, to get very crystal clear about finding recommendations coming out of here, and having both of you here as subject matter experts is a very valuable source of that primary information that ultimately our committee will deliberate on. So just to be clear, do you believe that the Emergency Act in its current context adequately serves its intended purpose? Professor West? Professor Roach?
No, I don't. I would decouple the definition of emergency from threats to the security of Canada. I think it's kind of apples and oranges because
I want to get into specificity, Professor. I appreciate, but I don't have time on that regard. I want to know specifically what amendments would you propose to this committee?
I would propose of getting rid of 2C and going with a different definition of public order emergency, keeping Section 3. I would propose ensuring that the inquiry, and I know you believe it's within your powers, would have access to solicitor-client privilege.
For the record, that we are the Grand Inquest, not Inquisitors. I think that's Star Wars, but I digress. Professor West, in your opinion, what recommendation should we make?
Change the definition of public order emergency to remove emergencies caused by threat actors, which is essentially what it is now. I would still, if Parliament wanted to have the ability to respond to emergencies caused by terrorism, subversion, espionage, etc., I would think you would need to still keep that tied to 2C. But if you wanted a public order emergency to actually deal with public order emergencies and issues around potentially critical infrastructure, I would change the definition of a public order emergency to meet those requirements. Alternatively, you could have a public order bill, like the United Kingdom has introduced in its legislature, that provides specific powers and different offenses around critical infrastructure and threats to created by public order disturbances.
Thank you. And you may have heard me, even in this meeting and in other studies, talking about the practical failure of policing. It is not within our mandate, it doesn't within our scope here to be able to delve into that, but there hasn't been a Royal Commission on policing since 1962. Professor Roach, I know that you've written about unequal policing. I think it's fair to say, for many people on the outside looking in, there was certainly a double standard applied to this particular group. Do you agree with my assessment that we ought to embark on a Royal Commission on Policing to be able to unpack the responsibilities of police?
Absolutely, I would agree, and I would also look at reforming the Reading the Riot Act provision in the criminal code, which is, archaic, just to say it.
It's dying seconds here. Would you also support a Royal Commission on Policing to be able to look at the mandates and the...
Absolutely, and there's...
Sorry, my apologies, Professor Roach. I want to get Professor West on the record real quick.
Sorry.
Especially the structure of the RCMP needs to be reviewed.
Just the RCMP?
Well, in particular.
Would you agree with the statement that
Yes, I do.
as it relates to the state of national emergency or the declaration, that it was all levels of policing that practically failed?
Oh, yeah.
In this instance?
The comment with respect to the RCMP wasn't tied directly to the Emergencies Act, just in general. I think that, yeah.
Okay, thank you. So we now have Senator Carignan for 4 minutes. The floor is yours.
Thank you. My question is for Professor West. And it's about the territorial nature of an event, when something is more localized as opposed to when it involves the entire country. I was looking at Perrin Beatty's speech, and at the time, on the 16th of November, 1987, he said that a state of emergency must be a threat to the entire country or be so broad that it goes well beyond the ability of the provinces to deal with it. So he's making the distinction between a local something as opposed to a national. So how does that square with the Emergency Measures Act?
I think if we look to the definition of national emergency, either A or B, that's where that is made clear. It has to be an emergency that's beyond the the authority and capacity of a province to deal with it. And then secondly, Part B has to deal with something that is, federal national jurisdiction that threatens the sovereignty, territorial integrity, and security of Canada writ large. So could you have a national emergency that is more regional in nature and isn't truly all across the country? I think so, but the issue is that it has to rise to the level of something that is of national concern. And so that takes it beyond the provincial jurisdiction and concern up to that more national level.
Thank you. I'm sorry, I don't follow you on Twitter, so I can't necessarily use your tweets to ask my questions. I don't know if you heard about this, but the mayor of Ottawa said that he had declared a state of emergency, but it didn't really give him very many powers. It was more a symbolic gesture. Now, I know you're not an expert in municipal law, but I did see your CV, and you have a lot of experience when it comes to emergency measures. So could you comment on that statement? Is it a symbolic statement, or does it carry more weight?
I'll try and answer your question. The measures are supposed to be necessary to end the emergency, and I don't think that anyone could make the argument that a measure or a symbol is necessary. Even using it as a communications tool of the severity of the issue and how we're planning to deal with it, I don't think that is what would rise to the level of necessity as required in the Act. Oh, sorry. I did not, in the municipal act.
So in terms of a municipality then, the mayor stated that he really didn't have the power to declare a state of emergency in a municipal context. There are powers of seizure and confiscation. There are powers that the mayor does have. Can you expand on that?
Emergency powers are limited to what would typically fall within the jurisdiction of the municipality. And so where you really see the most teeth all across the legislation, emergency legislation, is with the provinces. The provinces' emergency powers are by far the beefiest when compared to the municipalities and to the federal government. And that makes sense because the tools to respond to what we think of as a typical emergency rest with the provinces. So policing, for example, health services, emergency services are really, held at the provincial level.
That does conclude the round. We will now move on to Senator Boniface for 4 minutes. The floor is yours.
Thank you very much. Professor Roach, I just wanted to go back to section 17.1 because you didn't get a chance to kind of expand on that, and we have not heard much about that at this committee. Can you just give us a little more information around that and how it interacts with the balance of the Act?
Sure. I agree with Professor West that you need to have 2C plus you need to have section 3. But then section 17.1 says when the governor and council believes on reasonable grounds that a public order emergency exists and necessitates the taking of temporary measures. So it seems to me that the issue for cabinet and the issue that may be explored in that legal opinion is whether they have reasonable grounds to believe that a public order emergency exists. So my own view is 2C is 2C, and it doesn't mean something different through the Emergency Act if it's incorporated as it is in the Emergency Act, whether that's a good idea or not. I think you've heard from me, but I think that's what I would like to know, how the Attorney General of Canada interpreted that, because there is this increasing deference to government decision makers and expertise. And so I would like to see how the belief on reasonable grounds in Section 17 was interpreted, but I also wish it was Christmas.
I'd like to take you back to your comments in terms of comparing the situation in Ottawa and the situation in Toronto. I think we've heard evidence at this committee that Toronto had the benefit of the Ottawa experience.
Yes. I mean, to a certain extent. I mean, we also know, though, that whether it's Operation Hendon or whether it's the ITAC reports, Ottawa knew that this was coming. So I don't think it's simply that they had the benefit. I think they had the benefit of being criticized for what they did in G20, and they actually got their house in order, and they had police service and a police service board and a police service who were working together functionally. They actually had a mayor who bothered to sit on the police service board and wasn't off on his own frolic negotiating with protesters. So I think a lot can be learned from the Toronto experience. And, I've said critical things about the police. You know that, Senator Boniface, but I also think we need to give credit where credit is due. And the two places that I think you should look at to see what went right is what happened with the actual Parliament grounds not being breached in light of what we know happened in 2014, and also what was done in Toronto. So I think these are significant successes, and that your committee should, in a balanced way, learn both from failures, but also learn from what worked.
Agree with you. I think the one piece that we have to also keep in mind, and Commissioner Carrique testified that, and I may have my numbers slightly wrong, but on one day he had over 100 incidents going at different points. And so I think we also have to talk about capacity when we think about this going forward. Would you agree with me?
Absolutely, but we also need to think about the Solicitor General in Ontario taking some sort of responsibility when it comes to those capacity issues.
Thank you very much. That does conclude the second round. We do have the ability to do a third round. And what I wanted to do is, oh, my apologies. What happened? No, it was originally slotted for Carignan. Should excuse, there was 2 senators in this round. But we are contemplating a full third round, 5 minutes. And I just wanted to put that to the committee. I understand that there are some people who want to split times. So I'm seeking direction of committee that we pursue with a 5-minute round, recognizing that Senator Patterson is not here. We'll reclaim some of that time. I do know that the guests have been here for quite some time, both in person and online, and I would also like to just get direction from the committee on whether or not a 5-minute health break might be appropriate, or do you want to continue to work right through?
Monsieur le Président, moi, j'ai pas de...
Chairman, I have no objection. However, our committee was also supposed to consider on future business, and we have motions before the committee. We were going to do that between 8 and 9:30, and if we have another round, there will be less time for the consideration of those motions. Am I to understand that? Because we're wrapping up at 9:30.
That is correct, with a little bit of discretion on the bookend there. That I'm at the direction of committee on what you want to do.
Okay.
We could go for less time if you want to reclaim some of that. So we could do 4-minute rounds, perhaps. It is at your discretion. 4 minutes? Wow, this is great, guys. Thank you for your cooperation. We're going to go with 4 minutes, and we will acknowledge the split times. For the parties that want to do split time, are you requesting a hard stop at 2? Do you want me to intervene or just let you figure it out? I'll let you figure it out. Thank you very much.
Can you just clarify for senators how
You have a full round. Yeah. Yeah. Okay, thank you for allowing us just to work that little bit of housekeeping. With that being said, we will begin with the third round for 4 minutes with Mr. Motz. Mr. Motz, you have the floor for 4 minutes, sir.
Thank you. I'll be sharing my time with Mr. Brock. Dr. West, you have stated that we do not label entire protest movements terrorist because some amongst the protesters are looking for an opportunity to leverage that protest to potentially create violence. You also stated that we have never labeled blockades or other non-violent but illegal means of obstructing critical infrastructure as terrorism. They do not fall under Section 2 of the CSIS Act, no matter how broadly one interprets it. Can you elaborate on those statements, please, for the next minute and a half?
I was referring in the past to violent protests that we've seen, G8, G20, as we've heard. We've also remember the Summit of the Americas. And in those cases, we know that there were violent elements of those protest movements that sought to take advantage of the protests to advance their violent agendas, but we did not label those protests, and we do not consider those protests terrorist. We've also seen a series of blockades in this country's history that were nonviolent but illegal, and we have refrained from calling them terrorist. And because they lack that serious threat of violence, that's been proper in my view.
So how would you classify the Freedom Convoy?
I think it is a constellation of blockades and protests. I think what we heard was that the serious threats of violence, again, like in the past, came from those who sought to co-opt the movement to advance their own violent agendas, but that I've seen no evidence to suggest that that was the majority of the protesters or the ultimate aim of the protesters. So I don't think that that's much different than protests that we've seen in the past. While there may be those amongst them, certainly those in Coutts, who fall under the definition of terrorist and pose that threat, we typically don't label the entire movement as a result, or the entire protest movement terrorist because of the actions of individuals.
Thank you. To both professors, one of your colleagues from Queen's University, a professor by the name of Dr. Bruce Pardy of the law school at Queen's, wrote an article today in the Toronto Sun. Heading was, "Invoking the Emergencies Act was clear overreach." And he sets out examples as to why he forms that opinion. I don't know if either of you have had a chance to review the article. That's not really relevant to my question. My question to both you, Professor West, firstly, do you agree with that particular statement? If you don't, explain why.
It's a little too definitive for me because I haven't, like I said, my opinion is based on my understanding of the law, and I stand to be corrected on my understanding of the law, but I haven't seen anything yet that shakes me from that. So if the act was interpreted more broadly, so as a hook to use powers that were needed to dispel the Emergencies Act, knowing that a tenuous legal position was being taken, I think that's overreach.
Thank you. To you, Dr. Roach.
Yes, I also tend to agree, and in response also to your colleague's question, I would say even at Coutts, after those arrests, the blockade self-policed and took itself down, and that's something that, again, I think is quite important to bear in mind, because I agree with Professor West that we shouldn't go around branding people and whole groups as terrorists.
We will now move over to Mr. Virani. Mr. Virani, you have 4 minutes. The floor is yours.
Thank you very much. And I'm going to return to Professor Roach. With respect to sort of the intelligence components, you've been asked a number of questions about this, and I'm going to return you back to something that you wrote about in one of your articles dated, this one's dated February 14th. Of this past year. Canada has been slow to recognize violent far-right extremism despite incidents of far-right terrorism, including a 2014 shooting rampage in which a man who wanted to overthrow the government killed 3 RCMP officers, a 2017 killing of 5 men at a Quebec City mosque by a man motivated by Donald Trump, David Duke, and anti-Muslim sentiment, a 2020 attempt by a military reservist to confront Prime Minister Justin Trudeau, who the reservists feared was imposing a communist dictatorship in Canada, and a 2021 killing of 4 members of a Muslim family by a man wearing a swastika. How do we get at the source of that kind of bias in terms of our intelligence apparatus that is not adequately addressing or evaluating the threat that is posed by far-right extremism? Can we do that through recommendations at this committee, and what would you propose that we recommend?
Well, I think we need greater ministerial oversight of both CSIS and the RCMP to see whether they are devoting enough resources and have the adequate training to address these. So ministerial oversight as well as executive oversight review and the National Security Committee of Parliamentarians.
Article, you actually started citing Professor Dworkin, so it really made me feel like I was back at the Faculty of Law. But you talked about sort of equality and notions of equality in terms of how it impacts the legitimacy of policing. And I think this is really critical. Somebody who lived through the parts of the blockade here in Ottawa, about sort of how people started to treat the police in terms of no longer respecting them in the same way, which I think is problematic from a societal perspective. But it was about, you wrote about many criticized the police for accepting the freedom occupation and blockade for over 3 weeks when they take more aggressive stances against Indigenous land blockades and protests by racialized people. This compounded the equality problem if a lack of adequate intelligence about the danger of far-right violent extremists using the occupation contributed to the policing failure that allowed the Ottawa occupation to last 3 weeks. Ignoring equality creates a risk that both the police and the law will be viewed as illegitimate. But I also found it interesting because you talked about a bit later in the same passage about the fact that some criticized the police for talking to the protesters. But you said the talking isn't necessarily the problem. It's the fact that if there's going to be talking to the protesters, it needs to be done equally, whether the protesters are the Ottawa occupiers or whether the protesters are an Indigenous group or a Black Lives Matter group. So can you unpack that a little bit for us in terms of where you see policing going forward in terms of correcting this sort of double standard, if I can use that term?
Yeah, no, and that's something where my views may have changed with some of the evidence that's come forth since February 14th, when I probably, on Valentine's Day, I should have been doing something other than writing a piece. But in any event, I think best practices emerging out of IPERWASH, emerging out of G20, is that the police should have a plan to talk to the protesters, to provide the protesters with an opportunity to self-police, while recognizing that if they fail to do so and they fail to obey the law, then the police have to come in. And I think that the police also need to maintain their neutrality. And I think various police forces who are now pursuing discipline against officers who express their political views about the protest, I think that is part of maintaining their neutrality. But I think if we had an advanced plan that told everyone we're going to talk to protesters until X point, and we also had transparent political direction to the police, this would respond to some of these concerns about inequality.
That does conclude the round with a little bit of opportunity to conclude the thought. We will now go on to Monsieur Fortin pour 4 minutes.
Mr. Fortin, you have 4 minutes. Thank you very much, Chair. Ms. West. We know that the Emergency Act is an act that is applied during exceptions. I mean, it's sort of like taking out the heavy machinery. It's the heavy part of the law. It has existed for a good 30 years. It has never been used, and its ancestor, the War Measures Act, was proclaimed for the last time in October 1970 in the circumstances that we're all familiar with in Quebec. So this is an act that isn't used very often and that will be invoked in extreme cases, exceptional cases. Now, in this case, and the situation that was prevailing in February, one might say that one can justifiably say that there were things that were happening that shouldn't have been happening. There were people occupying Ottawa for weeks. That made no sense. And so I agree that the occupation had to end, but it was localized. It was in Ottawa. There were other things happening on the Ambassador Bridge and in Coutts, etc. But these were local situations. And then the Emergency Act was invoked, but it was being invoked in these, I won't say that they were unimportant, but they could have been managed, and they were in very different areas. So I do not feel that invoking the Emergency Act was justified, but that's not my question. What I want to know is when you invoke the Emergencies Act in situations that do not justify invoking it, what should the consequences be, in your opinion? The fact that you're using this legislation that really is extreme, it's exceptional. It hadn't been done over the past 30 years. The last time was October 1970 under the War Measures Act. So what should the effect of that be if it wasn't justified, if its use was not justified?
Well, I think if it's determined that the use was not justified, that it's up to this committee to make that clear to Parliament. Parliament has all of its remedies available to it. And I think most importantly, it's up to the citizens of Canada to decide whether or not a government that unjustifiably invokes the Emergencies Act should continue to govern.
Mais est-ce que ça a une incidence?
However, does it have any legal implications, or does it have? Are there any consequences, further consequences, broader consequences, like like international order, for example?
But old democracy is really the cure to that.
Merci. Professor Roach?
Thank you. Professor Roach, do you have the same opinion that there aren't any further consequences, or should there be any when you invoke the Emergencies Act if it wasn't justified?
I agree that it's up to Parliament, but I also would add that, you are one of at least 3 accountability mechanisms that are ongoing, including the Rouleau Commission and the ongoing challenge in the federal court. And one of the things that I saw after G20, where, more than 1,000 people were arrested, was this multiplicity of accountability mechanisms actually seem to perversely have diluted accountability. So sometimes you can have too much of a good thing. And although I think it's important that we have these multiple accountability mechanisms, and I wouldn't advise to take them all away, I think Canadians are going to have to digest the verdicts from at least 3 of these accountability bodies, of which this joint committee is one of the 3.
That does conclude the round. I'll pass the chair over to Senator Boniface, and so I can proceed with 4 minutes. 4 minutes, that's correct. And on the topic of accountability, you did mention in an article entitled "The Dilemma of Mild Emergencies" that are accepted as consistent with human rights. You stated that not having a requirement to examine the actions of the province in which the emergency occurred is an omission. Is it your recommendation to this committee that we contemplate providing a mechanism that would force the issue of provincial accountability and review?
Yes, I think as far as you can go is to provide for a formal request to the affected province to appoint a parallel inquiry. Obviously, that happened with mass casualty. That's not happened in this case.
Certainly an important consideration. And I know, obviously, Section 33 is invoked all the time in terms of provincial sovereignty, but in your remarks, Professor, you mentioned, if I recall, federal preemption. Can you expand on that and maybe perhaps provide some context to that statement?
Yeah, on matters of national security, there is a potential for federal preemption, also under peace order and good government, and the emergency parts of our federalism constitution. So just like the Security Offences Act can make both the RCMP and the Attorney General take the lead, I think that this may be an area where Parliament could legislate federal preemption. I can't guarantee that provinces would not challenge that as an infringement on their constitutional duty under 9214 for the administration of criminal justice, but I think that's a possibility.
In a practical sense, if that happened and that was legislated federally and the provinces refused to act or rejected this assertion, and of course in this very wild time of the Alberta First and Saskatchewan and Manitoba and all the others who want to break away from the country, if we were contemplating that, at least then the onus would be on them. Would you agree?
Yes. Yeah, and the Security Offences Act, which involves federal preemption, has been around since the CSIS Act, and I'm not aware of any challenge to it.
So on the topic of ideologically motivated violent extremists, do you share my alarm that there was reports of high-ranking military, including Joint Task Force 2, members of the Prime Minister's security detail at one point, former and current serving military people in the armed forces, as well as connections with the police, Were you concerned with the assessment that that there was a infiltration of that element within the convoy?
I was concerned to an extent. I'm more concerned about the weapons and explosives found at Coots, but certainly that is part of an intelligence looking at the group. I also worry a little bit, though, that we have the police who seem to have more freedom to look at open source material and social media material than CSIS does. And to me, that again raises whether the police can actually distinguish or have the necessary intelligence expertise.
And on the previous comment, could you reflect on the infiltration of high-ranking armed services and police, people who had insight into logistics and tactical procedures that we've heard testimony had never been seen before?
Well, yes.
I'm sorry, Mr. Roach, the question is for Professor West.
Oh, sorry.
Starting point, I don't think there's anything wrong with retired service members and military members, police officers being part of a protest movement or helping lead that protest movement. It's the concerning part of it is if those members are also have violent extremism goals. That's what concerns me.
Like overthrowing the government?
Through violence, yes.
Thank you. That concludes my round. I'll take the floor back and then pass the 4 minutes on to Senator Boniface. You have 4 minutes. The floor is yours.
Thank you very much, Chair. Professor Roach and Dr. West, if you'd like to weigh in on this one. Trying to come up with a recommendation that deals with perhaps mandatory involvement of the provinces or something in a context that says you can't just step back and not reply or not attend meetings when people are trying to get a solution together. Is there any way within a amendment to the Act or such, or if the Act's redrafted, as I suspect it should be, that you could actually make that an obligation?
Well, Senator Boniface, I hope that you're going to look at Section 20 of the Emergency Act, because I actually don't know why that was there originally, but it does, preserve the municipal and provincial silos when it comes to policing. And I'm not really sure whether that is necessary. And in fact, this emergency may demonstrate some of the flaws of Section 20.
I honestly can't think of something other than a legislative requirement for an invitation to the provinces, similar to the inquiry or a recommendation. But at the same time, I would say then we also need to amend what consultation is from the federal government to the provinces and make something of a required meaningful consultation on that end as well. I think we shouldn't be looking at one without the other.
I'm looking at it through the lens of the public who don't always understand the distinct roles. And, policing, certainly people thought the RCMP were policing here when it's municipal and such like. And I'm just trying to figure out ways that you could actually compel people to at least come to the table.
I wonder whether this is something the Uniform Law Commission could look at, which sometimes deals with overlapping jurisdiction. Just a thought.
Governance structure for policing, both in its effectiveness, but in its role. When you look at the RCMP and the OPP, which you'd be familiar, do you see board-type governance would be in a better place to assist with this?
Yes, board type, but with adequate staffing.
And enough of a role, responsibilities that are driven by legislation.
Exactly.
Okay.
We will now pass On to Senator Carignan for 4 minutes. 4 minutes.
Oui, merci.
Thank you. My question is for Professor West. You said that there's no other consequence other than perhaps political consequences. But when questionable actions are taken, if you're talking about the Charter, for example, let's say seizures that are a breach of Section 8, or other actions, would you not say there are possibilities to compensate under the Act? And there is also civilian recourse for actions that might be taken, like, for example, an abusive seizure of something.
Any finding by the Commission, this committee, or the federal court that suggests that it was unreasonable or unjustified to evoke the Act would form the foundation for potential charter claims. So people could make the claim that their rights were unjustifiably infringed under the Charter and seek a remedy, potentially a monetary remedy from the courts.
OK. Donc, on pourrait voir...
So there could be some sort of civilian prosecution, or there could be, for example, an apology on the part of a prime minister. I mean, Trudeau seems to have apologized off and on. I mean, could he apologize for having invoked the Emergencies Act?
I'm sorry, I didn't. I'm not hearing your interpretation. So
Oui, est-ce que...
If you want to repeat.
Was the question if we just get
apologize.
apologies? Certainly. That would be one way of trying to repair any harm from an unjustifiable use of the Emergencies Act. But I suspect that findings in court might be more meaningful.
Now, I'd like to talk about solicitor-client privilege. I don't know how much you know about solicitor-client privilege. But the Minister of Justice has often said, well, I can't share this because of solicitor-client privilege. So who can waive that?
So in this case, it would be Cabinet or the Prime Minister.
Okay. Donc le Premier ministre...
And so the Prime Minister or the Cabinet then could waive that. So if we were to bring the Prime Minister here as a witness, we could ask him if he's willing to waive that solicitor-client privilege in order to speak.
Il y a aussi la renonciation implicite lorsque...
Now, when you're, say, communicating legal opinions to third parties who aren't necessarily in the Cabinet, the same can happen. For instance, Mr. Vigneault seems to have had access to the legal opinion, and he wasn't a member of the Cabinet. And he wasn't part of the decision. So isn't there an implicit, then, renunciation of that solicitor-client privilege if that information is given to a third party?
So I would say no. Having been a former Department of Justice lawyer, my client would be the government. And anyone within the government that needed to make that decision would have access to that opinion. If it was important for them to have just Director Vigneault's opinion based on that legal opinion, I don't think it would be improper for him to have seen it and as a member of the as a party to the government.
Okay. Donc faudrait aller à plus...
So it would have to have been shared with more people than Mr. Vigneault. It has to have gone beyond that, the circle, for example.
Anybody within government supporting the decision-making within Cabinet, it would be justifiable for them to have access to that opinion, and it wouldn't be a breach of solicitor-client privilege.
That does conclude the round. Thank you. We now have, for the last round, and thank you very much to the witnesses who've stayed through this, we have Senator Harder for 4 minutes. Sir, the floor is yours.
Thank you very much, Chair. And again, thank you to the witnesses, particularly for staying later than anticipated. Professor Roach, I want to go back to the issue that you were discussing several times tonight about the fragmentation in the nature of Canada's police system. and how that was observed in the course of the events last February. You referenced Toronto a couple of times, and Senator Boniface was trying to get in on that as well. I'm not suggesting that Toronto benefited from the knowledge of the Ottawa experience alone, but it was sequential. I take your point about the mayor, the different attitudes of mayors and the local city police forces, but surely there is a difference also at the level of the OPP in terms of its integration in the approach that was taken in Toronto versus the reluctance to become involved in Ottawa. Would you agree with that assessment?
That the OPP played a greater role in Toronto than it did in Ottawa? Is that the question?
Yes.
Senator? I think so, but I'm not confident in making that factual judgment. But I mean the OPP certainly I know played a big role in Windsor. I'm actually not sure about whether it played a huge role in the two Toronto weekends. But you may be right.
Well, as a resident of Ottawa, I sometimes felt I had to remind the province of Ontario that Ottawa was in the province of Ontario. There was lots of appropriate attention, as there should have been, at the bridges. There was lots of appropriate attention at the city of Toronto, but there was not the degree of attention politically and through either the Premier or the Solicitor General of Ontario with respect to what was going on here. And that leads me back to your earlier comments about fragmentation. And the fragmentation is not only institutional with regard to the RCMP mandate, but it's also the rules of the game as they interact with those provinces that have provincial police forces. And would you agree that there is a need to have written down memoranda of understanding of how to coordinate in events such as this, that we have some basis of confidence that events like we experienced last winter will be managed more coherently and less fragmented?
Absolutely, that we need a framework for public order policing because it's not only here, it's also G20 and others where we have 3 levels, and sometimes if you include Indigenous forces, 4 levels working together. So I think we need to work on that and have these protocols and ideally have as much of them in public as possible. There may be some operational detail that can't, but yes, we need to plan on how to coordinate our 4 levels of policing. And I would include in that, the Parliamentary Protective Service, in some cases, even private security. Policing is not simply a monolith.
Thank you. I very much agree with that and would reference the inquiry that is taking place in the Senate of Canada with regard to the need to overhaul the RCMP mandate and role. It is an inquiry that I hope can lead to a broader parliamentary conversation around the issues you've just raised. Thank you.
Thank you. Noting the time now is 8:34. I want to thank both witnesses for appearing before us and staying a little bit later for the good and welfare of the committee. We will now certainly bid our adieu and let you go back to your lives. I will suspend the meeting for about 5 minutes for a health break, in which time we'll return for our business section of the meeting. I recognize Senator Harder. Senator Harder, sir, the floor is yours.
Thank you, Chair. I'll be brief, but I would like to move the motion standing in my name that has been circulated. It reads as follows. Following the last meeting in December, that A, the committee invite no further witnesses, B, the analysts be instructed to prepare a summary of evidence to be distributed to members no later than February 10th, 2023, C, any discussions regarding its report takes place in camera, and that D, the committee present its final report in the House of Commons and the Senate no later than March 31st, 2023. Colleagues, this committee has by then gone over a year, and I believe it's important for us to have the framework for our ability to get to a report that can make a meaningful contribution to the consideration of Parliament. Thank you.
I'll recognize Mr. Motz. Mr. Motz, on the motion.
Thank you, Chair. While there is general agreement with the principle where Mr. Harder wants to go with this, I would certainly have some proposal for a sub-amendment if Mr. Harder is amenable to it after further debate. Or do you want me to make it now? Okay. Well, Mr. Harder, I would propose that we reassess after Rilou publishes his commission, and that the motion be amended in paragraph A, by adding until the Public Order Emergency Commission's report has been published, and then B, by deleting paragraphs C and D.
So we've heard the amendment as opposed by Mr. Motz. I recognize Senator Boniface on the amendment.
I'm just would ask that he repeat it.
Yeah, sorry, I will, happy to. So that the motion be amended in paragraph A, by adding until the Public Order Emergency Commission's a report has been published at the very end, and then B, by deleting paragraphs C and D.
On the amendment, we have Senator Harder.
Thank you very much. I will be brief. I would not support the sub-amendment as described, only in referencing the fact that this committee could make any decision when it reconvenes in the new year, and it may or may not be of the view of the committee to review this report or this motion. But I think it would be very helpful to direct the analysts to begin to prepare the work of putting together the summary of evidence, and that we have the expectation amongst ourselves of tabling a report by March 31st, 2023.
So I'd like to put myself on the list for the moment, and in doing so, I'll continue by passing the chair over to Senator Boniface. Just so that I'm clear, I think, what I'm hearing is not a material departure from where you wanted to start, but you're suggesting, Senator Harder, that this is by no means officially wrapping it up. It's simply not inviting witnesses and then preparing a report. But I want to understand that you also recognize receiving the published report from the Public Order Emergency Commission will be a part of our overall consideration. Is that correct?
Yes, Chair. That's why I selected the dates that I have on the expectation of when the Rouleau Commission would report. And I'm also open to the notion that the committee, as a majority, might wish to hear a witness that we haven't thought of. But I think it's very important for us to put in play an expectation around which we can govern the work of this committee between now and when we reconvene after the break, and that we have as a deadline, notionally at this point, March 31st, 2023 for our report, and act accordingly.
Okay. So this is simply a ceasing of the work plan as it's contemplated with the long list of witnesses to turn our minds and our attentions to the ultimate reporting phase. And just as it relates to rationale around it being in camera, would you be willing to just respond to your rationale around that particular point?
Yes, certainly, Chair. The rationale for in-camera is to ensure that as we develop the report, we can have a frank and an interior conversation around how we see the report evolving and on trying to seek, if we can, a consensus around recommendations in particular. That might not be unanimous. There might be other views that will be incorporated that don't seek unanimous consent of the committee. But I think that work is best done, at least in the experience that I've had, in an in-camera fashion.
And I would say, from my perspective, my experience with our work in the House, report stage stuff does typically happen in camera, just to confirm that that's also the practice in the Senate?
Correct.
Okay. I'm satisfied with that. So we do have an amendment. It's not a sub-amendment. There's an amendment on the floor. I recognize Monsieur Fortin.
Thank you, Chair. What I was going to ask was this. Would Senator Harder agree to dividing his motion and that we would vote on each paragraph A, B, C, and D separately?
That's fine.
I'm in the hands of the chair. My own view is it's a whole, but you know that's for the committee.
Yeah, Mr. Chair, if I might, I've not seen that done before, and I think it's important to vote for it in its entirety because it reads as a comprehensive whole. Right? Because then
Just to be clear, Mr. Fortin has not relinquished the floor yet. He put a question, but I just want to make sure before we jump on interventions that you have completed your intervention.
I was putting the question to Senator Harder because it's his motion. Personally, I think these are different areas. For example, it says the committee invite no further witnesses. Mr. Motz was suggesting a date of the Rouleau Commission. Okay, that's possible. But then, you know, in terms of the final report, that's another subject. So these aren't the same items. And as furthermore, setting a date, perhaps set a valid date, perhaps it's not, but this is yet another subject. So I think we have 4 separate subjects here, and I wouldn't want to vote against the entire thing. It would be unfortunate because I may be in agreement with some of the parts, but not all of them. I'm sure we'll be able to agree on 2 or 3 of these elements.
Procedurally that this motion has been tabled, it is in order as it stands. What you're asking him to do essentially would be to withdraw the motion and then re-put it point by point, and I get a sense that's not the intention. So from that perspective, while the intervention is appreciated, it doesn't have like a procedural precedent. Are there any other people who would like to speak to the amendment? So given that we don't have a speakers list, I'd now like to put the question on the, it's not a sub-amendment, it's just an amendment. Right, so on Mr. Motz's amendment that if we could have the clerks read it out just before we go to the vote.
Mr. Motz moves that that Senator Harder's motion be amended by in point A, adding the words until the POEC report has been published, and secondly by deleting points C and D.
So you've heard the motion as amended. You've heard the amendment as put. We will now proceed to the vote.
I'm not sure I understood. So you're deleting C and D? Is that what you're doing? You're removing them. So we're voting on A and B because C and D would be removed.
D'accord? Everything is good? Okay, we will proceed.
The Honourable Senator Boniface?
No.
The Honourable Senator Carignan, CP? Oui. The Honourable Senator Harder?
No.
Non.
Ms. Ambrusen,
Nope.
Mr. Varani,
No.
Mr. Brock,
Yes.
Yes.
Oui.
No. On the main motion, so we'll wait for her to finish.
Wait for the count.
We can count, but we'll wait for it to be official. We'll find out shortly.
So yeas 4 and yeas pull 6. So you got,
Nays, let the record show.
sorry, nays 6, yeas 4.
The motion is defeated. We will now go to the main motion. Mr. Brock?
I have a second amendment to propose. It's titled, "No Witnesses Until Justice Rouleau Publishes a Final Report by June 23." The motion be amended, A, in paragraph A, by adding, quote, "until the Public Order Emergency Commission's report has been published," end of quote. And B, in paragraph C, by adding final before the word report. And lastly, C, in paragraph D, by replacing March 31st with June 23rd.
Okay, I would suggest that your First Amendment is redundant. I think that was just defeated. It's a repeat of Mr. Motz's motion, respectfully, is his amendment.
But it encompasses the whole thing again, the amendment.
You can't relitigate an amendment that you just lost.
We lost C and D, we didn't necessarily lose A.
If you would like to rephrase it and include, like, I don't think that amendment is in order if you're repeating what we just did, but if you would like to just add your second two, I'm willing to entertain that being tabled, but we're not going to repeat amendments.
I'll withdraw the reference to A in paragraph A and seek amendments in B in paragraph C and C in paragraph D.
Just for the purpose of the committee, may you please repeat that so that the clerks and everybody can understand that again?
B in paragraph C by adding final before report, and C in paragraph D by replacing March 31st with June 23rd.
Mr. Brock, would you like to speak to the amendment now? You do have the floor still.
Yeah, my position is as stated.
Okay. With that being said, is there anybody else on the speakers list? Mr. Motz?
I would just like to add, while I think we have general agreement around the table that we need to look at getting the report from the Rouleau Commission. We need to see how that plays into our report from the analysts, and we need to get the analysts working, as Mr. Harder has indicated, on working toward a report for us as a committee that we can start deliberating and making recommendations. Given the number of weeks that we sit after the Rouleau Commission is to be out, it would be impossible for us to be able to have a March 31st deadline in all reasonableness. Even if we don't call anybody anymore, it would be virtually impossible for us to get through the evidence to be able to look at his report and then turn around and make recommendations based on that by March 31st. And so if we set a June 23rd, obviously that's the last day before we rise for summer, I believe. But if we're sooner, we're sooner. But that should be that's it. We have to be done by then. And if we're done sooner, so be it. I think that's reasonable, and it also it allows us to have a fulsome report. And we've heard some great recommendations, on all, from everything from policing to the interpretation of law, et cetera. So I think it would serve us well, and what our role is to give us some latitude on time.
Any other comments on the amendment as proposed? Senator Boniface?
If I could just ask the mover for clarification on, if he was willing, on why on C, final report, what are you distinguishing? I'm trying to understand why that's important.
While that's being discussed, just for the consideration of committee, I think it's important to note that the original motion proposes, I believe we would have about 6 meetings, right? So 3 hours a meeting. That's fair. That's fair.
17 of Feb, right? Summers around there, 17th to 20th of February? So, twenty-third of Feb is when it's due, right? 20th.
2,
I
3,
think we
that's
said
only 3
two-
meetings to
we
do a
said 2
report.
weeks? I think we said 2 weeks after that.
Were you?
Yes, I'm ready.
Thank you.
Thank you, Chair. To answer Senator Boniface's question, the rationale behind that amendment is contemplating the other motion that has yet to be tabled by my colleague, Mr. Motz, with respect to the legal opinions, the release of the legal opinions, which, if that motion is passed, could result in an interim report before the final report. So I don't want to foreclose the possibility that there could be a further report before we issue that final report. That was the rationale.
So if I could pass is there any, well, I'll see Vereni, and then I'll look to put myself on the list and pass the chair to Senator Boniface.
So
Mr. Vereni?
just with respect to what Mr. Brock just raised, I would say that that's a bit speculative in terms of how we should address this motion based on future motions that may or may not come to pass. The second piece I would raise is that March 31st is still 5 weeks after the tabling of the Rouleau Commission report in Parliament. There's nothing that requires us to only sit once per week. So if there's a concern about timings of sittings, that could be addressed through sitting more than once per week. The committee is the master of its own destiny in that regard. But I'd also put out there that we should also not conflate the scope of what the Justice Rouleau has been asked and what we've been asked in terms of our own terms of reference. The motion that was passed in the House and in the Senate, those are technically different entities. And that's important to keep in mind, because I think the impression was given that we need to be responding to what may be a 300 or 400 page report by Justice Rouleau. Thank you.
Senator Boniface, just for my own intervention. So I have a keen interest, and I think I've stated this, that I am willing to accept whatever findings come from the Rouleau Commission and hope that we would use that in our contemplation of the report. I recognize the time crunch, and I also recognize the remedy that is just put forward, that we could contemplate using constituency weeks or requesting additional time. As is stated right now, I'm not sure after the final report having 3 meetings would be enough. So I think we would logistically look to have to spend more time if we wanted that deadline. Having said that, I also respect the notion that if new information were to come to this committee, that we would be able to contemplate that information in an open forum by calling a meeting that would include committee business, if we were to contemplate documents that would be received or what have you. I think to this point, we're doing pretty good on this motion, and I'm hoping that we can continue to iron out a pathway forward here. But as it stands now, I am in support of this, recognizing that there could be a commitment that we would increase the frequency of our meetings in order to have the report, as well as provide an open forum for which information could be contemplated in public. And I'll just, acknowledge the fact that anytime we're in camera, at the passing of a motion, we can move to go out of camera and into public domain again. So that they don't preclude themselves, at least in my understanding. And as far as like interim reports go, I'll just say that like what I'm not on for are motions that contain a conclusion by any party of this committee that we would then, spend hours in a filibuster contemplating in a very public, partisan way. I'm hopeful that, any reports that come in a way that respects the precedents that is set in our other committees, that we build the report together and that we submit it as a committee. So those are my comments. Senator Boniface, I'll take the floor back and I'll recognize Senator Harder.
Just very briefly, Chair, I would share your observations of the intentions behind this. And obviously, as we go forward, we may or may not review that. But I think it's important for us to be expeditious, recognizing that it's been, by the time we report, even with this date, over a year.
That being said, okay.
You've given me the floor, Chair? Thank you. I've been listening to this, and I can understand everyone's concerns. I'm not sure whether I should propose this now or later, but could we not agree perhaps on just voting against all this? Because what if we were to say something like the 30th of May? In terms of sitting more often, as Mr. Virani suggested, we have explored this in the past. It won't be possible because there won't be clerks, interpreters available, rooms available. We have asked to sit 2 days a week. That's what we did in the beginning of the fall, and we were told, no, it's no longer possible. 1 day a week only. So let's not just imagine that a miracle is going to happen and we'll end up being able to sit 2 or 3 times a week. We won't get that. We have 1 day a week. And it's true that the 31st of March is a bit too soon. I think Senator Harder will agree with me that that doesn't give us much time for discussion. So if you don't want to go to the June 23rd, maybe we could say the 15th or the 30th of May. I mean, it's all very well to vote, but perhaps there's a way to come to a gentleman's agreement on a date, and it would make things easier.
I don't want to correct you on the record. I'll tell you after. So I think we've heard that rationale. We will recognize Ms. Bendayan.
Oui, j'aimerais juste.
I would like to hear what the clerk has to say. I don't remember it being impossible to find other slots for meetings. Is that true that in 2023 we won't be able to find more meeting times? I think it'll be impossible to confirm today.
Oui, mais c'est.
There's a new year coming.
I don't want to put the clerk in the position of having to have a crystal ball, but I would say this, that, I'll take a chair's prerogative to say that if we're in a scenario where we're denied, then I would ask the indulgence of this committee that we, revisit an extension on the dates. Because there's certainly, I think we're getting to a place where we understand where we need to be with this committee. We're doing really good work. So would that suffice? That if we came to a place where that, the question is in the parliamentaries' agreement, would it suffice that if we got to a place where that request was denied, then at that time you would put that motion to have it extended? Okay, you don't have to comment. You're not compelled to speak. I did see here, and then I'll go here.
Just very briefly, Chair, in the spirit in which I earlier intervened, I'd be happy to, in that circumstance, have a discussion in committee as to whether or not, and if so, for how long, it would be appropriate. But let's get going on our work.
Mr. Motz?
Well, our committee coordinators have indicated that we do not have a calendar yet for 2023 for committees, and we do not have any indication that there will be more resources available than there is now. So we can guess that there might be, but I mean, what committees are going to be canceled and night sittings might be scheduled as they are, what impact that will have. And even if we go to, it doesn't have to be to the end of May, but something reasonable, and something draw in the middle, Senator Harder, where we make a decision to March 31st is impossible, and maybe the end of June is not impossible, is too far away, and we can meet somewhere in the middle, but like May 19 or whatever. But it's just we need to be reasonable in the dates that we have, because I don't see us, getting things done in 3 meetings. And even if we had an extra meeting a week for 3 hours, I still don't think that'll be enough.
And just for everyone's appreciation, I believe that the pressures on scheduling meetings arise during sitting weeks, but they don't arise at all during non-sitting weeks. And there are at least 3 non-sitting weeks. There's 2 non-sitting weeks in February and at least 1 in March. So I presume there would be added flexibility at that point in time for scheduling committee time.
I will note that we have tried that in the past, and organizing members of parliament in particular during constituency weeks is a difficult task at the best of times. So we do have an amendment. It is being contemplated. We've had lots of different interventions on the amendment. Is it the committee's will that we proceed to a vote on the amendment, or are there other interventions that might provide some amicable middle grounds? So given that we've exhausted the list, we will proceed to the vote. Can you please read the amendment again? If you have it as... Yes, please. Barry.
B in paragraph C by adding final before report, and C in paragraph D by replacing March 31st with June 23rd.
Okay, the amendment as put, we will now proceed to the vote.
The Honourable Senator Boniface?
No.
Honourable Senator Carignan? The Honourable Senator Peter Harder?
No.
Ms. Ben-Dayan.
No.
Ms. Davidson.
No.
Mr. Varani.
No.
Mr. Brock.
Yes.
Mr. Mott.
Yes.
Monsieur Fortin.
Oui.
Mr. Green.
No.
Yeas pour 4, 4. Nays contre 6, 6.
The motion is defeated. So on the main motion, Mr. Motts.
Thank you, Chair. Well, if you don't succeed a couple times, you got to try a third time, right? So how about this? An amendment by adding at the end of paragraph A the following. Provided that the joint clerks invite each individual organization listed on the analyst's work plan, dated May 11th, 2022, who have not appeared before the committee, to submit a brief to the committee for its consideration, and briefs with briefs encouraged to be provided to the joint clerks within 1 month. And the joint clerks shall arrange for any briefs provided to be translated, circulated to committee members, and published on the committee's website. End of quote.
Okay, you've heard the amendment. Do we have any interventions on the amendment? I will... Oh, sorry, Mr. Brock. Well, I actually recognize Ms. Ben-Dayan first, and then we'll go Ms. Brock. Ms. Ben-Dayan, the floor is yours.
Thank you, Chair. I was just going to say that the witnesses we have heard to date were all questions. We had an opportunity to ask them questions. And these are fundamental principles of the work of a committee, that is to say the witnesses be treated in the same way. And I do not think it would be fair then to accept written testimony without having an opportunity to question them and to see and hear them. So I think what my colleagues are doing is really just drawing out this study further for another year. Because once those documents have been tabled, I'm sure they're going to want to see those witnesses to be able to ask them questions. So I think they're trying to do indirectly what didn't work directly.
Mr. Brock, the floor is yours.
With all due respect to my Liberal colleague, she presupposes incorrectly. What we are trying to do, and I listened very carefully to Senator Harder's support with respect to his motion, and I heard him very clearly say that this does not potentially close the door in terms of hearing from further witnesses. That is an opinion that is not clearly stated within the motion itself. So I mean no disrespect to Senator Harder, but unless it's actually there and unless we actually vote on it and agree on it, we may not get consensus to recall or to call further witnesses. So what this does in turn, I'm quite shocked that my colleague from the Liberal side would take exception to this, because what we're trying to do is to expedite the process. We all agreed that the list that we had on our work plan was quite unmanageable in terms of where we are right now, almost a year into this process. So we're trying to expedite those witnesses that are not that contentious by allowing them to file their reports. We still have further academics on that work plan. Those academics must surely would have a prepared statement or would be in a position to prepare a written statement. So this is all about efficiency. It's not about complicating things. And it gives specific impact to Senator Harder's proposal that we have yet to vote on. Thank you.
And I will hand the floor, I will recognize Mr. Virani, and then
You can go to yourself first if you
yeah,
want.
I don't know. I always feel like that's a bit abusive of the chair, so I'll recognize you and wait till.
Well, I would just say, in terms of sort of being efficient, I think the most efficient thing we probably did was several months ago when we said we would take holus bolus, I think is probably the right expression, everything that was before the Rouleau inquiry and incorporate it as evidence into this proceeding. That provides us with a tremendous level of efficiency. And I note that the vast majority, if not every single bit of that evidence, has been tested by cross-examination. As we saw, the Prime Minister was questioned by about 9 different counsel when he appeared on that Friday a couple of weeks ago. I think the utility of cross-examination to me was never more critical than here, when we had a witness appear who had to be invited a second time and thankfully arrived. And this is my personal perspective, but the testimony from the individual from Give, Send, Go in terms of his response to questioning really demonstrated really a lack of credibility in terms of what he was presenting. And I think that's informative for all of the members of the committee in terms of how we deliberate and what kind of recommendations we develop. So I think the utility of cross-examination is actually quite vital. The only thing that we're incorporating by reference has already been tested by a cross-examination in that other form before Justice Rouleau. So I think the point is well put by Ms. Bendayan.
Pass the floor over to Senator Boniface. It's my perspective that there's a higher standard of care that we have in navigating this review and in contemplating the public consultation process, just as parliamentarians and in committee. I'm actually in support of taking this, and I take Senator Harder at his word when he says that if there is a bombshell or if there's a significant departure that would require us to have greater scrutiny or the demand for a cross-examination on contentious briefings, because it needs to be clear, briefings procedurally are put on footing with testimony as it relates to the analyst's notes. So I will be supporting this motion for those reasons, because I take in good faith that if we had continued down our work plan path, which we had agreed on at one time, that we would have invariably seen those witnesses. And I think I'm going to test the goodwill that, should this motion pass, I would look to the Conservatives to support us on the main, although sometimes I've seen that from committees where that doesn't always happen, in the spirit of trying to move this thing along. So for those reasons, I'll be supporting the amendment to have the briefings be contemplated. And I will also go on the record to say that if there are material departures from the committee's kind of consensus around the report, that I would also support calling back a witness that has presented a briefing that requires a little bit more cross-examination and scrutiny. So I'll take the floor back and then recognize Senator Boniface.
Yes, I just, for the mover of the amendment, I'm wondering if it is essential to seek it from everybody, or whether we could prioritize the witnesses that have not appeared before the commission. So some of the people you would send to have already appeared before the commission, I think. And I'm just wondering if you would give, perhaps the co-chairs could take a look at and then sort those lists in a way. And
I may not have been
I mean,
clear, but
they can choose not to respond. Perhaps that's the way you leave it. But I just think it's confusing for people on the other end of the receiving the information.
I may not have been clear when I read the motion, but this is for witnesses who have not yet appeared, not for those that have, but those
Before the commission, Rulo Commission.
they call the commission ones.
Yeah.
May I provide a little bit of,
Maybe the senator can repeat.
yeah.
Within the list, because I don't have the list in front of me, I don't know, but there may be within that list, I suspect there is within that list, people have already appeared before the Rouleau Commission, of which case we already have their evidence, right? So it doesn't, I just think if I'm on the receiving end of, we want more information when they've already testified under oath, it doesn't make sense to me.
Yeah, I would certainly agree to that, absolutely, and would also suggest that the clerks limit the amount of information we receive. Like we don't want 30 pages, but it should be like a 5-page brief. If they can't say it to us in 5 pages, what more can they say? So something along those lines that we trim it down a little bit and may make it reasonable and manageable.
Okay, do we have any other interventions on the proposed amendment? Senator Harder?
Just to take the suspense out, Mr. Chair, I will, in the spirit of your intervention, vote for the motion, living in the same hope as you do.
Do you want it on division, or are we going to do the whole thing here?
Do any of the colleagues around the table have a sense of how many people we're talking about?
The remainder of the work plan, I think, had been circulated earlier. I don't have a number off the top of my head because I don't have the work plan.
Could, Mr. Chair, could we suspend for a moment?
Sure, I think that's reasonable. We're going to suspend for 3 minutes. Do you have a work plan? folks take their seats. I believe I saw a quick flash of the hand from Mr. Varani. Mr. Varani, the floor is yours.
Yeah, so we've had some discussions, and the Liberal members of the committee would be minded to support it on subject to one condition, which is that the three co-chairs be empowered to vet the list, not simply for the purposes of excluding people who have already presented at the Rouleau inquiry, but also for the purposes of ensuring that there is some equity as between the people who have been invited to provide a written brief amongst the various invitations that have been issued by various political parties.
That seems reasonable.
The clerk looks a bit puzzled. So what I mean by that is that so that you have equity amongst those witnesses who are being asked to provide briefs among the Conservative Party, the Bloc Québécois, the NDP, and the Liberals. And the Senators. My apologies.
We have consensus on that. So can we pass the amendment as referred to the chairs? Okay. So let the record show that. Oh, really?
That the motion be amended by adding at the end of paragraph A the following: provided that the joint clerks invite each individual or organization listed on the analyst's work plan dated May 11th, 2022, who has not appeared before the committee or the POEC, to submit a brief to the committee for its consideration, with briefs encouraged to be provided to the joint clerks within 1 month, and that the joint clerks arrange for any briefs provided to be translated, circulated to committee members, and published on the committee's website, and that briefs be limited to 5 pages, and that the 3 co-chairs vet the list to ensure equity amongst the parties.
Perfect.
Mr. Chair, I hate to nitpick, but I think the word each of the witnesses who did not appear before the committee, I think the word each of should be removed, because otherwise it would be impossible to have equity among the parties. So there's a bit of a contradiction. Yes.
No procedural shenanigans here, so that worked out well. So we're going to let that amendment be shown as carried unanimously. We'll now move on to the main. So we're going to move to the main motion as amended. Okay, shall we go to the vote? We will now move to the vote. Thank you. On division? C'est bon. Bon travail.
Good work.
On to the next motion. Mr. Motz, the floor is yours.
Thank you very much, Chair. We circulated a motion here a couple days ago with respect, I have too much sugar in my system, with respect to the documents that we've been trying to get at as a committee. And this particular motion addresses, it's very similar to the one we had back in May. It took some of the concerns that were related by some committee members with respect to that and invited the law clerks to be part of it. And again, this is, we have some timelines on it, as you'll see in the motion. And, you know, we've heard from a number of witnesses repeatedly, and as well as the Commissioner Rouleau, as well as the lawyers there, that it's unfortunate that we are somewhat operating in a vacuum without some of these documents, and so we need to pursue getting those documents to this committee, and then in turn giving those documents to the Public Order Commission as well.
Thanks very much, Chair. I will not support this motion as drafted. I think it is somewhat convoluted in process and enjoins our law clerks to undertake work that is not their area of specialization. With respect to the sense that this would provide information to the Rouleau Commission that it was unable to secure, I would simply like to put on the record the words of Commissioner Rouleau of November 25th, page 261 of the transcripts, line 18 to 25, where he says, quote, "Most importantly, I am satisfied that I now have the evidence that I need to make the factual findings and to ask the questions I've been mandated to ask, namely, why did the federal government declare the emergency? How did it use its powers? Were those actions appropriate? These are questions that, as I said at the outset, the public wants answered, and I am confident that I am now well positioned to provide those answers. I think we should pay attention to Justice Rouleau.
I think what we heard through the commission, more than Justice Rouleau's final comments, he had factual findings. What he had, he feels that he can make a decision, but he's still making it in a vacuum, quite honestly. And his own lawyer has indicated the unfortunate reality that the government is withholding this information. The Canadians, this is about transparency to the public. And the public needs to have some sense of what the government relied upon. This committee needs to have some sense that the government relied upon, as well as the commissioner. And so this is an attempt by this committee to do what we were asked to do, and that's to look at all the information that the government relied upon to invoke the Emergencies Act.
So I have a sort of a preliminary question, which is just that what I have from Mr. Motz was something that was circulated on November 30th, which is about a 5-page motion. And then I've got something that was circulated by Mr. Motz on December the 6th, which in some respects there's some overlap, but I'm just a bit concerned which motion exactly are we discussing right now as between those two motions?
The motion from November 29 has been is not pursued, has been tabled because we weren't able to that particular day, and so this is the motion of December 6th that stands.
So we're now talking about the motion from December 6th. Okay, so then my next question would be with respect to the motion from December 6th. I'm not actually clear that this committee, or any parliamentary committee for that matter, has the authority or the ability to direct material to be brought to the attention of a quasi-judicial inquiry being headed by Justice Rouleau, or any other inquiry for that matter. And there's 2 occasions on which this document, as proposed, suggests doing exactly that. So perhaps the clerk could clarify us on that issue?
Not sure when you're asking the clerk to clarify, are you asking the clerk to make a legal opinion on your opinion?
But just is this within scope for a parliamentary committee to order something to be brought to the attention of a judicial inquiry that's already concluded its evidence gathering? I know what a judge can ask for, but if they're not asking for something, can we forcibly send something to a judicial inquiry? Do you know of any precedent in that regard, Madam Clerk?
I think he's suggesting to send it, though. I'm not sure that it's a fair question to put to the clerk. We are the masters of our own domain within this committee and have the ability through voting to determine what we want to do with information that we receive. And it'll be up to the quasi-judicial inquiry to accept it or not.
Well, perhaps the law clerk we've got one of the law.
You're not the Senate clerk.
The Senate law clerk, yes? No. Well, I do think it's kind of salient to the analysis, Mr. Chair, in terms of trying to make a determination as to how we'd be minded to vote on this matter. It's asking the committee to do potentially something that's beyond our jurisdiction to do so. The Joint Clerk shall be directed to bring the order to the attention of the Public Order Emergency Commission. That's sub K, and sub G says documents to be provided to the Public Order Emergency Commission forthwith upon receipt.
Okay, I appreciate you sharing your perspective. Are there any other perspectives on the motion? Yes, Senator?
Mr. Chair, while I appreciate the thrust of it, I am concerned in terms of the role that we're asking the law clerks to play. I'm not sure that's the role they play. And so because of that, and I've been upfront with this in my concern on this and the previous motion, and for that reason, I wouldn't be able to support it.
So if I may, Chair. Sorry. Am I next on that?
I recognize Mr. Motz.
Well, thank you, Chair. Are you proposing then, Senator Boniface, that the law clerks be completely removed from this and those documents be asked to come to this committee? Is that what you're asking?
No, I'm just speaking strictly to this. I share the concern that Mr. Brani raised because I asked the same question around the Senate, the reference to the Senate in here. And so I'm wondering whether this is something that, so I guess I'm not proposing anything. I'm just putting my position on the table.
Motion? Ms. Bendayan?
I believe this comes from the Green Book, but I'm double checking to get a page number. But just in terms of the discussion, Mr. Chair, that you were having with my colleague, Mr. Vrani, it does state specifically that a committee has no power to send documents to a court or other body, only the power to send for documents. And so I just wanted to provide that information to colleagues. Yes, I am.
I'll take you at your word. I have
I'm
no
looking
reason
for
to
the
doubt
reference.
that you're not citing appropriate protocol. We have a motion that's been duly put. Do we want to call the question? Okay, let's do that. We'll call the question. So the motion as put, and we'll allow the,
Before we get there, Chair, if I could ask a question?
is it a procedural one?
I'm just looking for consensus. Is there any consensus that we want these documents? Want any documents? Is that, if we have to
Mr. Chair, I
adjust
believe
wording?
you called the vote.
I did call the vote procedurally. There was an opportunity, an ample opportunity for intervention. I did call the vote. We will now proceed with the vote.
The Honorable Senator Boniface.
No.
The Honorable Senator Carignan. Honorable Senator Harder, PC.
No.
No.
Ms. Dumberson,
No.
Mr. Varani,
No.
Mr. Brock,
Yes.
Mr. Motz. Monsieur Fortin,
Oui.
Mr. Green.
Je vote pour la motion.
Yay?
Yes. She didn't get my French?
Yeas pour 5, 5. Nays contre 5, 5.
Procedurally, on a 5-5, the motion fails. So that concludes the motions that had been presented. Unless there's any other business, I would just note that we had a hard stop at 9:42. And with that being said, is it the committee's will the committee is adjourned? We're adjourned.